Assalamualaikum and hello everyone. So this is our video presentation.
So let's move to the first case.
This case is about Leah being asked to leave the unit by Anna's sister Jen. We will identify the issue and giving some advice to the related parties. Jen urged Leah to leave the unit because Leah has been paying the rent 40% lower. In these circumstances, did Jen have the right to expel Leah from the unit? In the context of the Contract Act 1550, this contract is known as a proposal and is interpreted in Section 2A. Anas proposed to Leah to let her stay in her house, and Leah accepted the proposal. This is related to the Section 2B, where a contract can be bound by acceptance. According to the case Leah and Jen, this type of offer is unilateral and bilateral. Unilateral is where Leah has an obligation, and bilateral is where Anas and Leah agreed to face the obligation together. According to Present Corp Sendirian Berhad v. Edward Leong and Ors. 1982, a contract can be conducted through words and the willingness of both parties to join the contract. The contractor can make an agreement and specify the terms during the discussion process. In this case, the offer was made by Anas with the term she specified earlier. Leah agreed to join because it suits her current situation. Therefore, Jen practically have no right to dismiss Leah from the unit since both Anas and Leah has made the agreement of contract beforehand.
Hello, my name is Vincent Wong, no matrix BB201103330. I will present for the paragraph 3. The issue is whether Anas cancelled the offer from Max and accepted the offer from the Dean. For the rules, if seen from the Contract Act 1950, Anas can cancel the offer from the Max and accept the offer from Dean. This happens when a counter offer cancels the original offer. According to case Hyde vs. Range, on June 6, the defendant made an offer to the plaintiff to sell his land for a price of 1,000. On June 27, the plaintiff agreed to buy the land for a price of 950. The defendant rejected it. On June 29, the plaintiff expressed agreement to purchase the land at original price of 1,000. The defendant refused to sell it to the plaintiff. No valid contract exists because the plaintiff stated a purchase agreement at a price 950. In this case, Anas cancelled the contract between him and Max after he get a higher price offer from Dean. Anas at the first accept the offer from Max to sell his motorcycle for 1,000 ringgit because he need to cover his credit card debts from his lavish lifestyle. But before he give the motorcycle to Max, he got a new offer from Dean for Rm 3,500 ringgit, then directly sell to Dean, and Anas returned 1,000 ringgit to Max by plus 100 ringgit. In general, even Max already buy the motorcycle, but he doesn't get the item yet and still in Anas' hands. Anas can cancel the contract and return back Max money and sell to other buyer that is offer a higher price for that motorcycle. So that's all from me. Thank you.
Hi, my name is Alina binti Zul. My matrix number is BB2011007N. I'm going to present the third case, which is Nadine and her friends with the management of One Borneo Hub Mall. According to the issue of Nadine and friends, this term of contract is referring exemption clause. However, the Contract Act 1950 contains no provision dealing with exemption clause, and therefore, the Malaysian courts have followed the English common law when considering this aspect of law. According to English common law, an exemption clause is a contractual term in which one party attempts to limit the extent of its contractual obligation or regulate the other party's right to damages or other remedies in the event of a breach of contract. There are certain standards of notice to protect the position of the recipient of document contains exemption clauses, which the first one is notice must be contemporaneous with the contract, and the second one is notice must be reasonable sufficient, and the third is the term must be part of contractual documents. According to the cases of Taunton v. Shoe Lane Parking 1971, Mr. Taunton had never been on the premises before, therefore was not aware that one of the 8 conditions printed on the wall contained an exemption clause that excluded the garage from any liability for the injury or harm caused to their customer and their premises. When returning back to his car, Mr. Taunton got seriously injured. Consequently, he broke an action against the garage. Thus, the Court of Appeal dismissed Shoe Lane Parking's appeal. Above all, the court held that as Mr. Taunton did not know of the garage, did not take reasonable steps to bring its existence to his notice, it was not binding upon Mr. Taunton. Hence, as referring to the issue between Nadine and friends with the management, Nadine and friends will be bound by those terms of exemption clause as long as they are sufficiently brought to the notice before or at the time the contract is made but not otherwise. Therefore, Nadine and friends will not be bound by the terms unless they acknowledge of the disclaimer on the terms which create a valid exception of contract.
Hello everyone. So I will continue to the cases of Nadine and friends with the mall management of One Borneo Hypermalls. So according to the case of Chapatan versus Very Urban District Council in 1940, it was held that a ticket issued by an attendant to hire the council take chairs did not constitute a contractual document. It was considered a means whereby a user of a tick chair could prove that he had fulfilled the obligations of paying the appropriate charge of its hires. Thus, as referring to Nadine's and friend issue, they will not be bound by the term as the content has come too late. Moreover, according to the case of Parker versus South Ester Railway Co. in 1877, the requirements of incorporations by ticket were stated as: did the purchaser of the ticket know that there was writing on it? Did the purchaser know that the ticket contains or refers to the term? Or were reasonable steps taken to bring notice of the terms to the purchaser's attentions? Therefore, Nadine and friends seems to not know that there was writing on the ticket and not knows that the tickets contain or refer to terms, as there are no any tickets or notice or even disclaimer that they're supposed to receive or notice when they drive around the parking lots for the 40 minutes. Consequently, the management did not take any reasonable steps in order to bring notice of the terms to the purchaser's attentions. Certainly, there was no proof of Nadine and friends knowing of the existence of the disclaimer or exempting conditions. Therefore, all of them will not be bound by it. In conclusion, Nadine and friends are able to demand for compensations from the mall management. They will not be liable by the damages as they are not sufficiently brought to the notice. Instead, the management will be liable as they have not taken any reasonable step in order to bring notice of terms or disclaimer to their customers. So that's all from me. Thank you.
My name is Nur Izaida binti Jalius and I will proceed to the last case. The issue is Vince loan RM 5,000 to a licensed money lender sharing in the name of Ezra and promised to repay the loans and agree interest within 2 months. But Vince tried to default and did not repay any of his loans after 2 months. And then the rule is under Contract Act 1950, Section 19 states that if a person enter into a contract and give wrong information or statement, and this matter can be found out easily only by ordinary inspection, then this contract is voidable. According to Section 65, if the contract is void, every benefit the person earns must be returned to original party.
Hi, my name is Wang Yinji. Application. In these cases, Fan entered into a law content with Shen. Then 2 months later, Shen found out that Fan did not go through the contract and went to Fan's house to ask it. Because Fan used the RSSM to devise Shen to sign a contract and did not perform the contract. Shen could get Fan to repay the law through the legal channels. Conclusion. In general, Fan and Shen's contract is partly false, but the truth is discovered through Shen's effort. So the contract is irrecoverable, and therefore the contract takes efforts, and Shen can make Fan perform the contract through the legal channels.